Hello, everyone. Thank you for joining us this afternoon. Welcome to PACO's Workers' Comp Roundtable. Today is September the 19th, 2024. And with us today is Attorney John Goodman. John Goodman is a longtime workers' comp attorney. He has been representing injured workers for a number of years and before the Industrial Commission in all of the courts. He has written briefs in support of, amicus briefs on different cases regarding the plaintiff's bar, on behalf of the plaintiff's bar. So he is very well versed in the workers' comp realm, and I would certainly consider him a workers' comp expert. John is going to share with us today a case law update. And I know, John, there have been a couple of new cases that have come out over the past 6 months, 9 months, year that I've seen a significant impact from. So waiting to hear what you've got to say about those.
Okay. All right. Thanks. I appreciate that, Angela. These things are not formal. So if anybody has questions, I assume you can post those to Angela, and feel free to interrupt.
Yes.
Also, just a disclaimer, just a disclaimer at the outset too. I mean, obviously, I represent injured workers, so I'm going to be looking at this through that lens. We're very active, my law firm, and then different organizations that I'm part of in terms of representing injured workers and their interests, as Angela stated. So, to the extent that there's a spin on any of the cases that's going to be a pro-claimant one, it's not meant to offend anybody. It's just where I come from and what I do to represent my clients. Angela is definitely correct. There's been some major changes in the law based on the decisions from the Supreme Court. There really are two major issues going on right now that have affected, I think, everybody, not just the injured worker side or the employer side, but also the Industrial Commission itself. And those would be the changes to the temporary total statute 4123.56F. Those changes were made in September of 2020, but there's not been a Supreme Court case yet interpreting those changes. The main case that's on that is called AutoZone. That's a 10th district decision interpreting the statute, but that case, the 10th district decision, was appealed to the Supreme Court, and it's been up in front of the court for some time now. Honestly, it could be decided any day. I'll go through it in here in just a second, but I guess I would say that the 10th district interpretation of the law is a quote unquote pro-claimant view of it. There's several reasons for that: the facts of the case, but then primarily the fact that the injured worker won at the Industrial Commission level. And that's a really important thing to discuss just in general, because when a case goes up on mandamus, it's important to think about who the parties are and who represents them. Obviously, you have the injured worker, the employer, if the employer is involved, but then depending on who the state agency is that's involved, then you have the Attorney General's office. So when the Industrial Commission is what they call the respondent, which is essentially like the defendant in a mandamus case, it's the Attorney General's office that represents the Industrial Commission. So when you have a decision from the Industrial Commission that grants compensation or otherwise fines in favor of the injured worker, and the employer challenges that case in mandamus, the Industrial Commission is represented by the Attorney General, and the Attorney General is going to be arguing essentially in favor of the injured worker, because that's what the Industrial Commission found administratively. That's the factual scenario of AutoZone. In AutoZone, the temporary total was granted. And so when the employer challenged that in mandamus, you have the Attorney General effectively arguing a pro-claimant perspective on that for the reasons that I just said. If it had been the other way around, I think there's a very decent chance that you would have had less expansive or maybe more pro-employer, however you want to say it, interpretation of 412356F. But as it is, AutoZone was a claimant decision administratively. And so in front of the 10th District, you have the Industrial Commission represented by the Attorney General arguing for affirmance or upholding of the Industrial Commission's decision, which again was in favor of the employee. I don't think that the current Supreme Court is going to affirm this decision. I think there's going to be some changes to it. Frankly, I'm a little frightened by what they're going to do. I don't think it's any dispute that or I don't think it's any crazy statement that we have a conservative Supreme Court. And when I say conservative, I don't necessarily mean in terms of their decisions, but in terms of it being a quote unquote Republican court or quote unquote pro-employer court, however you want to say that. We always like to think that everything is completely down the middle and unbiased, but I think that's a pie in the sky kind of notion. These things are political. We do have elected Supreme Court justices in Ohio, and they are obviously not lifetime appointments like you have at the U.S. Supreme Court. So things are to an extent political. So with that, I'm going to talk a little bit about the AutoZone case. I'm going to touch on some other cases that are, I think, relevant and maybe interesting. In particular, there's a case called Wilhelm that deals with COVID cases. And I think everybody has some interest in that. And then lastly, I'm going to discuss the Dillon case, which is a major Supreme Court of Ohio case that has really changed things. And from our perspective as injured worker counsel, very, very frustrating case to deal with. But actually, everybody, I think, is frustrated by it, including the Industrial Commission.
Exactly. I think they've been very frustrated.
There's no doubt. I mean, obviously, doing this a long time, we know the hearing officers personally, not just when we're there arguing hearings. And off the record, it's very frustrating from their perspective when there's a major change in the law that no one asked for, which is the case in Dillon, and there's really no guidance that's been provided. So we really see different hearing officers reaching different conclusions based on the Dillon case, which is that stinks. One of the things about the law is it's supposed to be something that we can tell clients how to predict and how to gauge their behavior based on that. And when you can't predict really what the law is or how it's supposed to be interpreted, a lot of that goes away, and it's very frustrating. It's very hard to tell clients what to expect because we don't know what to expect, and that's not how it's supposed to work. So very, very frustrating decision. But I'll get to that in a second. So let's talk about the AutoZone case. This is the first thing that's up. Hopefully everybody can see my the shared screen there. So factually what happened here was that you had a claimant who was injured and went back to light duty. He was working within his restrictions, and then at some point he got involved in a verbal altercation, I believe with a customer, and he was terminated by the employer after that. He didn't return to work. He did seek unemployment, which I'm not sure of the relevance of that, but the court included that fact, and he was awarded unemployment. But about 2 or 3 months after he was terminated, he underwent surgery for the allowed conditions. There was no dispute about that. Clearly, it was for the surgery was for the injury. So then he sought temporary total beginning the time of the surgery. He did not seek it for the period from which he was terminated, which is an important distinction. So this case brought this new statute, 412356F, directly in front of the Industrial Commission. And at the bottom of page 1 on the shared screen there, you can see the text, I'll highlight it there, of 412356F. Prior to this decision, we had a sprawling body of case law that probably everybody knows about, voluntary abandonment. And the voluntary abandonment doctrine went back to the mid-'80s in a case called Jones versus Laughlin, which was a 10th district case. And then it kind of snowballed from there. And the frustrating thing about voluntary abandonment is there were exceptions and exceptions to exceptions. If you had to make a pie chart of decisions rendered by the Supreme Court of Ohio in the 10th district about workers' comp topics, by far the largest share of that pie would have been voluntary abandonment decisions. There was just all kinds of litigation. The frustrating thing with voluntary abandonment is it was not statutory law. One of the things that stands out about workers' comp compared to other areas of the law is it's statutory in nature. There was no such thing as workers' comp in England. A lot of our law is what they call common law. We inherited it from England. And when we became an independent country, we adopted a lot of those things into our law, and that they generally refer to that as common law. There was nothing like workers' comp at that time. So the workers' comp systems that we have, and in particular here in Ohio, it's strictly a statutory creature. And so if you end up with something that becomes as pervasive as voluntary abandonment, you would expect that it would come from a statute, because that's where everything's supposed to come from. But that's not the case. It was actually originated by the courts. And that's always one of the interesting things that I think about in these cases or these situations is we always tend to hear that courts aren't supposed to legislate from the bench. They're supposed to apply the law, not create it. And voluntary abandonment was 100% a judicial creation. There's no doubt about that. And it also came from an allegedly conservative court. One of the arguments we always hear is that liberal courts are the ones that come up with the law and try to create it from the bench. But I assure you it exists on the other side, not only with voluntary abandonment, but in the Dillon case, as we'll see here shortly. So, but just keep in mind those facts of AutoZone. He was terminated, he didn't go back to work, and then he underwent surgery for the allowed conditions. You can see on page 2 of the shared materials there, basically 7 bullet points in terms of what the 10th District decided in interpreting 56F. The first thing is there's always a question about whether a statute is ambiguous or not, and they said it was not. They said the language speaks for itself. There's really 3 sentences of the statute. The first says if the employee is unable to work or suffers a wage loss as a direct result of the injury, then the person's entitled to compensation. And when we talk about 56F, there's 2 versions of that. There's wage loss and there's temporary total. That's what 56 covers. The second sentence basically is the other side of the coin. If there is someone not working or suffering wage loss as a direct result of reasons unrelated to the allowed conditions, then compensation should be not denied. I don't think there's anything particularly new in either one of those sentences. It's always been the case. If something's related to the allowed conditions, then it's compensable. If it's due to something else like aging or something that's unrelated to the allowed conditions, then compensation's not payable. That's outside of the workers' comp system. So neither of those sentences really break any new ground. The third sentence of the statute, however, definitely breaks new ground. It states, and I quote, "It is the intent of the General Assembly to supersede any previous judicial decision that applied the doctrine of voluntary abandonment to a claim brought under this section." So that's very new. And it's also very rare. Very, very seldom have I ever seen the General Assembly say that they are explicitly overruling a line of case law. The reason that particular language is so important harkens back to what I just said. Voluntary abandonment was a judicially created doctrine. It didn't exist in a statute. So when the General Assembly tells us that this new section 56F supersedes any previous judicial decision, to me, that means it's wiping out voluntary abandonment. Again, the whole origin and the whole existence of voluntary abandonment came from judicial decisions. And if the General Assembly says those are all superseded by this new section, then anybody who says, well, voluntary abandonment is still around, it's just, in a different guise now, I disagree with that. Because the plain language of the statute says that that's the case. It's to be superseded. So really, what are we left with? We're left with the first 2 sentences then. And the problem with those first 2 sentences, even though they're unambiguous, we all know there's all kinds of factual situations that arise that are very, very difficult to apply the facts to. For example, in this case, we know that the person had surgery for the allowed conditions. And so at least as of the time of the surgery, he was definitely off work because of that, because of the injury. But the employer argues that he was off work because he was fired prior to undergoing surgery. You can see a reasonable argument from both ends of the spectrum on that. The employer has a valid argument potentially, and so does the injured worker. So how do we break the tie? How do we parse that? Well, the 10th District in this AutoZone case said the legislature did not intend to codify voluntary abandonment. It intended to abrogate it, which is what I just said. So it's anything with voluntary abandonment, any of those case laws cannot be used when we litigate these things. They also said that we're not supposed to look at anything that happened factually before the period of compensation in question. So it's a question of focus and what time and what time frame are you going to focus on here. In arguing that the claimant was fired before he had surgery, the employer is talking about things that happened before the claimant sought compensation. Again, he only sought it from the time of the surgery. The 10th District in this AutoZone case said if we go back and talk about things that happened before the period of compensation in question, we're going to end up right back where we were with voluntary abandonment, because that gets into the issues of was someone fired? Did someone quit? All these kind of things that led us down the road to voluntary abandonment in the first place. So what they said is you're supposed to only focus on what the argument is from the time compensation is sought. So in this case, from the time of the surgery. And they said, when you have surgery for an allowed condition, then there's obviously a direct connection between your inability to work and the injury. And so therefore they said that's the end of the argument. If that's the case, compensation is payable and anything else is not something the injured worker has to prove or disprove. You can see some of the other findings and the other issues there that are in the decision from the 10th District. There's a quote from the case that I think is hands down the most important part of the decision. And it basically encapsulates what the hearing officers are doing when they apply this. And honestly, what the 10th District has decided in other cases since AutoZone, because AutoZone has been cited, I think 7 or 8 times now in other cases. And in all but one that I can think of, they have upheld grants of temporary total. And so I'm just going to quote this to you because it's very important. If the claimant's unable to work, 56F sets forth 2 operative questions to be eligible for temporary total. First, whether the injured worker is unable to work as the direct result of an impairment from the injury. And 2, whether he or she is otherwise qualified to receive compensation. 56F does not impose an additional requirement on a claimant to prove that he or she is unable to work solely due to an impairment arising from the injury. Only when an otherwise qualified claimant is not working as a direct result of unrelated issues is compensation to be denied. So let's unpack that a little bit. We've already talked about the first 2 sentences of the statute not really breaking any new ground. If it's related to the allowed conditions, it's payable. If it's due to something else, it's not payable. Fine, we've always known that. What is the meaning of the phrase otherwise qualified in 56F? I'm highlighting that right now on the shared screen. What do they mean by otherwise qualified? What the court in AutoZone said is that otherwise qualified is a reference to another portion of that same statute, 56A. 56A talks about things that can disqualify someone from temporary total. For example, are they at MMI? If you're at MMI, you're not entitled to temporary total. If you've refused a job offer, a valid job offer, you're not entitled to temporary total. If you have returned to work in any capacity, you're not entitled to temporary total. If your physician of record has released you to full duty, you're not entitled to it. So that's what they're talking about when they refer to otherwise qualified. So assuming the person is not MMI, has not returned to work, has not denied or rejected a job offer that was valid, or been released to full duty by the physician of record, then as long as the reason the person's off work is directly due to the allowed conditions, then that's the end of the inquiry. The employee or the injured worker does not have to disprove that they're not off work for someone else. That's for another reason. So in this case, for example, the injured worker did not have to prove that the reason he was off work was not due to him being fired. He just had to prove that he had surgery for the allowed conditions as of the time he sought temporary total. And because he was otherwise qualified, in other words, not MMI, all the other things that I just mentioned, then the statute is in favor of the injured worker and compensation should be paid. So that's what they said in AutoZone. So the important things to take away are you focus on compensation from the time it's requested. You don't look at earlier things. The second thing is if you can prove as the injured worker that you're off work directly due to something that's allowed in the claim, then that's pretty much the end of the inquiry, as long as you can show that you're quote unquote otherwise qualified. And that's essentially the finding. Now, that doesn't mean that injured workers always win. You definitely have situations where someone is off work directly due to something unrelated. For example, in the cases that I've cited in here, and there are a bunch of these, if you go through, I'm scrolling down a little bit, the Butler Village case, the Presswood case, Sowers, some of these others, Davidson. Those were essentially all situations where the court followed what they said in AutoZone, and by and large, they have granted periods of temporary total as long as the criteria that they set forth in AutoZone were met. Now, again, you can have situations though where the person is off work due to something that's unrelated, and if the injured worker can't show that they're off work directly because of something that is related to the allowed conditions, then the statute's clear. You deny compensation in that situation. I guess an example of that might be I have a work injury and I stop working, but I'm not taken off work by my doctor, and I have a non-related medical issue, and it turns out that the reason I went off work was because of that unrelated medical issue. In that instance, temporary total is going to be denied because I'm not working as a direct result of something unrelated to the compensable injury. So that would be an example of somebody who would not be entitled to compensation. So that's where we are right now with AutoZone. As I said, that's been pending in the 10th. That was the 10th district decision. There's a case pending in the Supreme Court, and it's been up there for, I think, over a year now at this point. So it could be decided at any time. And I think you're almost definitely going to see some changes when they make their decision from the Supreme Court. So let's talk about some other cases in here. Going to talk about the Heilman decision. This is at the bottom of the 4th page, I think. Sorry, 6th page in looking at the shared screen here. So Heilman brings up an issue of something that's kind of a pet peeve of mine. I've been doing this 25 years. When I first started practicing, if you dotted your I's and crossed your T's as an injured worker representative, the BWC file review doctors, and hopefully everybody knows what I mean by that. So BWC has a whole stable of doctors that just review medical records. They don't examine patients. They just review paper, and then they make a decision and say, yeah, this should be granted or this should be denied. The law, as I've set forth in the Heilman case here, is that a reviewing physician's role is not to question the accuracy or the reliability of an examining physician's findings. Instead, they're supposed to accept those as true and then make a decision. In my opinion, 25 years ago, and maybe even up until about 10 years ago, most of the file reviewers followed the law. They basically said, Dr. X has treated this person, Dr. X has personally examined this person, I'm going to accept what that says, and I'm going to agree with what the examining treating doctor says. I don't think that happens very much anymore. I guess if you had to put statistics on it, I would say maybe 80% of file reviews in the past used to agree with what we requested as injured workers, assuming we did our job and filed the evidence and had a causation opinion. I would say it's the inverse of that. I've seen situations now where you have highly credentialed, highly specialized surgeons, for example, people from Cleveland Clinic, highly respected orthopedic surgeons, and you have doctors from the BWC who have never laid eyes on the injured worker, couldn't pick them out of a lineup because they've never seen them or examined them, and they will disagree with and contradict what examining physicians find. And unfortunately, there seems to be no problem on behalf of hearing officers in accepting those type of reports. It's a real problem. It's not the way the law is supposed to be. We discuss it with BWC all the time. And the problem is it doesn't just hurt injured workers. It also drives the cost up for employers. If you have a clear-cut, for example, injury where someone hurts their ankle, for example, they go to the ER, they're diagnosed with a sprain, they go see somebody, an orthopedic doctor, there's an MRI, and it shows that there's a tear in the ankle. The doctor says this tear was caused by the injury, please allow these conditions. Assuming there's nothing wrong with that factual scenario or there's no other considerations, that should go through, right? Everybody wants the person to get treated and get back to work. That's the goal of the system. Unfortunately, in a lot of cases, we now see these file reviewers come in and say, well, the MRI showed a tear, but that could have been degenerative. No one that treated this person said it was degenerative. It's the file reviewer that's coming up with that on his or her own without ever examining the patient. So what happens when that occurs? Then this has to go to hearing. So the employer then either has to have their TPA or hire an attorney to go to hearing on something that should never go to hearing in the first place. The agency, the Industrial Commission, has to spend the money on conducting a hearing that should never existed in the first place. And the costs of all this and the delays and everything spiral for everybody. And that is what this Heilman case is important for, because it reminds everyone what the law is. File reviewers are not supposed to contradict what examining treating doctors say. If they're doing that, they're not following what the law is. And I challenge people on my side of the table, the Injured Workers Bar, all the time to make these arguments and to make them forcefully, because file reviewers should not be allowed to hijack this system. And I think to a large extent it's happened. It's very, very frustrating. And people may look at that and say, okay, well, if you're an employer, that's a good thing, because there's a lot more conditions that end up getting denied or end up getting challenged. But I question that conclusion. Again, you have increased costs for litigation. I don't think that helps the employer. And then maybe more importantly, you have someone who could have had surgery months ago and should have had surgery months ago and been back to work, but instead they're waiting on the hearing process. And all the while that injury is getting worse. Scar tissue is building up. There's animosity that builds up for people who are off work. There's all kinds of problems that develop because of these bad file reviews. And it's a real problem. So in this particular Heilman case, it was really egregious. You had someone who actually died, and you had the coroner who examined the corpse, who conducted an autopsy and everything. And then you had one of the file reviewers, Dr. Maresca, contradict what the coroner said. Dr. Maresca didn't do the autopsy. He never laid eyes on the cadaver. He had no idea, because he had never done any of these things himself, but yet he contradicted and basically said the coroner was wrong. And the Industrial Commission, unfortunately, relied on Dr. Maresca's opinion, which is, I mean, it's bad. This is not how it's supposed to work. The 10th District slapped that down and said, no way, this is not how this is supposed to work. Dr. Maresca was not an examining doctor. He's supposed to accept what the coroner said, because the coroner is the one who actually did the autopsy and saw the body. Someone who never did that and is just looking at paper is definitely not qualified to make that kind of an opinion. And so they disqualified Dr. Maresca's opinion. Again, I think you see this all the time in the cases these days, and it's very frustrating to us on the injured worker side, but I suggest it should be frustrating to everybody, because again, it results in delays and extra costs. It's a very frustrating situation there. All right, let's shift gears a little bit. I'm going to talk about this COVID case. This is at the bottom, I think, of page 7, going on to page 8 of the shared screen. It's the Wilhelm case. This is out of the 3rd District, Hancock County. The facts of it aren't super exciting, but the way that the court addressed the legal issues for a COVID case, I think, are instructive and important. So factually, what had happened in Wilhelm is the person worked for a drainage installation company. So right off the bat, when you think about people who are typically at high risk to develop COVID in the workplace, drainage installation guys are not at the top of the list. Typically, you think about first responders, right? Or people who work in a hospital, or someone who works in a nursing home. Those are the kind of people that are typically at higher risk, because they have higher contact with the public, potentially higher contact with people who are already sick, or in the case of first responders, you have emergency situations. You don't have the opportunity to say, hey, have you been coughing and do you feel ill? If you're there on a burglary call, you got to stop the bad guy. You don't have time to ask if somebody's got COVID or isn't feeling good. That's not the case with a drainage installation worker. So what happened in this case is the guy got COVID, and he said, I had a coworker that I had to work with, and he had COVID, and so therefore I got it in the line of duty in the course of and arising out of my employment, and therefore it should be compensable. That did not fly. The claim was denied administratively by the Industrial Commission, and the claimant appealed to the Hancock County Court of Common Pleas. At the Common Pleas level, you had some real problems with what the claimant's expert did. First of all, he was deposed. And one of the questions that you have to, or one of the criteria that you have to qualify when it comes to COVID, is that you have to be able to show that it's a quote unquote non-scheduled occupational disease. What do we mean by that? Well, there's a statutory definition for it. It's RC 4123.01F. You have to meet these 3 criteria, and I'm highlighting those in the shared screen. First of all, you have to show that you contracted the disease in the course of employment. In other words, you got it at work. And arguably, the guy maybe had that argument here. His coworker had it. He was around the coworker. Then he got COVID. Okay, maybe that's the case. But then the second and third criteria are a lot more difficult to satisfy for someone who's a drainage installation worker. You have to show that the disease is peculiar to the claimant's employee, employment by its causes and the characteristics. And you have to show that that employment created a hazard which distinguishes the employment from employment in general. And basically what that means is, do you have a higher risk of getting COVID because you're an installation, drainage installation person versus anyone else in the workforce? And I think the answer to that's probably no. I mean, again, you don't think immediately of drainage installation guys as people that are going to be at high risk to develop COVID. You think about hospital workers, doctors, firefighters, EMS people, someone who works at a nursing home. And then the third criteria is the employment creates a risk of contracting the disease in a greater degree and in a different manner than the public in general. What happened basically is that when the claimant's expert was deposed at the court level, the expert could not say that working as a drainage installation worker created a greater risk of getting COVID compared to other types of employment and compared to the general public. And so that's a major problem because you have to satisfy all three of these criteria in order to have a valid COVID case. So the injured worker lost at the Industrial Commission, and he also lost at the Hancock Common Pleas Court. He took it up to the 3rd District Court of Appeals, which handles Hancock County and a number of other counties in that area. And the 3rd District also said this claim should not be allowed. They said the claimant did not meet the criteria. You have to not only show that you got it at work, but you also have to show that the employment itself creates a risk that's greater of getting that disease as compared to employment in general and as compared to the public in general. And these are very hard cases. It's hard to meet that standard. Cited in the materials is another case with a similar outcome. That's called Yeager versus Arconic. And that was an earlier decision that was from the Trumbull County. I believe I think that's the 11th District Court of Appeals. Same thing. The person in that case could not meet those three criteria for COVID. Now, I have yet to see a reported decision where a COVID case was granted. Now, that doesn't mean COVID cases are not granted. I think we've all heard of cases being granted, and I certainly have had those. I'm lucky enough to represent a lot of first responders. That's kind of my niche in terms of being on the injured worker side. So I represent a lot of police officers and a lot of firefighters. And so we've definitely had compensable claims. And I think the reason we win a lot of those is because my clients come from a type of employment that meets the statutory criteria. Being a police officer or a firefighter does put you at a greater risk of contracting a disease compared to other employment. I'm, for lack of a better word, I'm a desk jockey. A lot of us are in administrative capacity. You know, if we're paralegals, if we're attorneys, we spend a lot of time in the office. We spend a lot of time behind desks. We're not necessarily exposed to the public in general. We certainly aren't exposed to people necessarily in emergency situations, although if your boss wants you to get a brief out, that might constitute an emergency situation, but that doesn't mean you're going to get COVID. So you can see the distinction there. Also, being a first responder or a hospital worker puts you at a greater risk of getting COVID than the public in general. We all know you can just get COVID by going to a grocery store or being at a concert or going to some place where there's a lot of people gathered. But when you have a job as a first responder or a doctor, you have no choice. You have to have those type of exposures, and you can't really control or predict the situations. And so that's why I think we win those cases more often than not. And you can see my note here. This is really up to us as injured workers representatives. You really have to do a good job vetting these cases. If somebody comes in to your office and says, I have a COVID case, I think I got it at work, my coworker had it, the very first question you should be asking as the injured workers representative is, what do you do? Because if that person works at an ice cream shop, I'm telling you, they're not going to get a COVID case unless you can show something extraordinary that half the staff had COVID and you can rule out the person's friends and family and they didn't go out in public. Those are very hard things to do. So you really need to look at the employment if you want to have a chance of getting a winnable COVID case. So that's what the Wilhelm case is and some of the issues that are relevant there. Let's fast forward then real quick. I want to talk about some of the changes that are happening with the VSSR situation that we have with the 10th District and really with the Supreme Court. And then lastly, I'll get to Dylan. So I think a lot of us have seen in the news that in the U.S. Supreme Court struck down something called the Chevron Doctrine. And what the Chevron Doctrine is, it goes back to a case called Chevron I believe it's 1984 from the U.S. Supreme Court. And what the court said back then is that if you have a law, either a statute or an administrative code that's ambiguous, in other words, it can be interpreted two different ways reasonably, who splits that tie? Who makes the decision? And what the Chevron court said is these agencies have been given the power to make determinations, and a lot of times they have experts working for them. For example, if it's the EPA, then you have scientists there. They're in the best position of anybody to split that tie when you have an ambiguous provision. And that there's nothing unreasonable or crazy about that. That's been the law for a long time. How does that apply to the Industrial Commission and VSSRs? Well, we have these very specific safety requirements that talk about things like machine presses and safety guards and any number of things that are in the VSSR code. So who's in the best position to break the tie if there is an ambiguous position, or if there's an ambiguous law? Is it the hearing officer with the Industrial Commission who sees these things day in and day out, or is it somebody else? Is it a judge? Is it the experts that the parties hire? And so that's a policy question. There have obviously been, as we go along, there's shifts in the way that the Supreme Court of the United States is. It can go from liberal, it can go to conservative, it can be some type of hybrid where it's in the middle. But I think everybody agrees where it is right now is generally a 6-3 conservative majority. So in a recent case, they struck down the Chevron doctrine. They said, we don't want to give too much power to these administrative agencies, because if the whole role of the judiciary is to solve problems when we have an ambiguous law or an ambiguous statute. And we also have something called the separation of powers. The separation of powers means the judicial branch is supposed to interpret the law, the legislative branch is supposed to set forth the law, and the executive branch is supposed to enforce the law. Those are all supposed to be very clear-cut and separate functions. And what they said is, because the administrative agencies are really part of the legislative branch, if you have the administrative agencies interpreting the law, then you really have a violation of the separation of powers, because it's supposed to be the courts that interpret the law, not an administrative agency. They've already set forth the law as the legislature and as the agency making the rules. So where does all that lead us? Well, in the Cassins case, and then also more importantly, and maybe more specifically in this Berry case, which is the 10th district, and these are in the materials here. What the court has now said is that if you have an ambiguous decision, the courts are going to be able to interpret those laws, those VSSR sections. It's okay if the Industrial Commission takes a stab at it, but what had been the case under the Chevron and even further back before that is you had what they call administrative deference. So, for example, if there was a gray area in a VSSR section and the Industrial Commission interpreted a way that was reasonable, then the courts are going to say, we're going to give them administrative deference. The Industrial Commission is the agency that's supposed to apply and administer workers' comp. They have expertise in that area, and so we're going to defer to what they say. Now, after the striking down of Chevron and after decisions like this Berry case, you have the court saying, wait a minute, we are not going to be bound by what the Industrial Commission says. If there's a gray area, we're the ones who are supposed to interpret that as the courts. That's our role. And if you allow the Industrial Commission, which is a legislative agency, to basically usurp our role as interpreting the law, that's a violation of the separation of powers. So I think this stuff is very interesting. A lot of this gets into constitutional law and separation of powers theory, but you can see how this trickles down to and kind of permeates some of the things that we do day in and day out in workers' comp. And that's definitely going on right now when it comes to VSSRs. Now, what does that mean? Does that mean anything the Industrial Commission says in interpreting a VSSR is going to be struck down by the court? No, that's not at all what it means. What it means, though, is the courts are not going to automatically say, well, the commission made this decision, it's reasonable, we're not going to look at it any further. What these cases now say is, okay, we know what the Industrial Commission said, but it's our job as the court to make the final determination. We are not going to necessarily defer to what the administrative agency said. We are going to conduct our own independent review of that ambiguous rule or law, and we're the ones that are going to make the determination. So, that can cut either way. That could cut for the injured worker. It could cut for the employer. If you have a VSSR that you win as the injured worker and the employer wants to challenge that, they don't like the way the Industrial Commission interpreted it, I'd say you have a better chance winning that case now on mandamus because the court's going to make the decision. They're not going to just defer to what the IC said. And the inverse would be true too. If you have a VSSR that's denied administratively and you want to challenge it as an injured worker, you probably have a better chance of winning now on mandamus because again, there's no more administrative deference when it comes to interpreting VSSR cases, or excuse me, VSSR rules. So if you want to read yourself sick on this, you can look at the materials in here. There's lots of detail. But those are some of the general things that are coming out of the 10th district when it comes to VSSRs. Let's talk then. There's a lot of other things going on, and you can read a lot of these in the materials, but let's talk about Dillon because that is a absolute hot button topic. It's probably the most discussed thing we have going on here.
Yeah.
So let's talk about what was going on before Dillon. So probably at least the last 30 years, what this deals with is a situation where someone is on ongoing temporary total. In other words, they're off work. They're already being paid temporary total. It's not a new period of temporary total. And I want to stress that distinction, and I'll explain why that's relevant here in a second. We're talking about ongoing periods of temporary total. When that's the case, and either the BWC or the employer comes out with a report that says this person's reached maximum medical improvement, then I think we all know how that goes. An industrial commission hearing gets scheduled. And at that hearing, it's the hearing officer's decision to say whether MMI has been reached. And if the hearing officer said that MMI has been reached under a case called Russell and under a case before that called Crabtree and a whole bunch of other precedent, the earliest that temporary total could be terminated was the date of the hearing. It could not be terminated, for example, as of the date of the employer's exam or the date of the employer's report. That's been black letter, clear-cut law in the law for a long, long time, at least 30 years and maybe longer than that. And it was part of industrial commission policy statements. It's been upheld many times by the Supreme Court of Ohio. And I think it was one of the few very stable areas that we had in the law. So what happened in Dillon? Well, in Dillon, you did not have, and this is very important, you did not have an ongoing period of temporary total. What you had was a new period of temporary total. The facts of Dillon involved the actual allowance of the claim. So when the Industrial Commission got this for a hearing, they were deciding whether the claim should be allowed. And they were looking at issues about which conditions should be allowed and then whether temporary total should be paid, and if so, for how long. It was a new period of temporary total, not an ongoing period. So at the DHO level, the hearing officer granted some of the conditions, denied some of the conditions, and then granted temporary total to continue. That's what the DHO said. The employer got a new report between the DHO and the SHO, and the SHO modified the DHO's decision. They basically did the same thing with respect to the conditions. They allowed sprains and strains. They disallowed disc displacements. And then they said, we are not going to have temporary total paid in an ongoing fashion. We are going to say that the sprains and strains reached maximum medical improvement as of the date that the employer's exam took place. So in other words, temporary total was not awarded in an ongoing fashion. Now, I don't think there's anything wrong with that legally, because again, this was not an ongoing period of temporary total. It was a new period of temporary total. The Russell issues about having to pay through the date of the hearing, that only has ever applied legally and historically when you have an ongoing period, not a new period. When you have a new period, the hearing officer has lots of discretion. They can deny it outright. They could award it through a certain date. They could award it to ongoing. They have a lot of discretion, and there's different options. And in this case, they exercised those options and they relied on some evidence to do it. For reasons I can't understand, though, the claimant's attorney decided that they wanted to challenge that. And they took it up to the 10th District Court of Appeals. And the 10th District, essentially, in my view, got the right decision. They said this is not an ongoing period of compensation. And so Russell and that whole idea does not apply. This is a new period of compensation. The Industrial Commission's always had the right to, fashion something else besides paying through the date of the hearing when it's a new period. And so that's going to be our decision. They denied the writ of mandamus. The injured worker, unfortunately, then took it up to the Supreme Court without anyone asking for the court to overrule Russell, without anyone asking for the court to completely pull the rug out from under 25 years or more of precedent and the way that everybody has always understood these things to do. and without even addressing the actual facts of the case before it, which is very disturbing because, again, this was not an ongoing period. The Supreme Court in this Dillon case said there is no requirement that the hearing officer pay through the date of the hearing. They can go back, and they in fact should go back and terminate compensation as of the date that MMI is found. Now, the problem with that is they didn't tell us what date that's supposed to be, because it could be different things. It could be the date of the exam, or it could be the date of the report. They didn't tell us which one. And now since Dillon, I've seen it decided both ways. But the court on its own overruled Russell and its progeny. But they didn't talk about any of the case law prior to Russell. And all those things said you're supposed to pay through the date of the hearing. What you have in this Dillon case is an extremely clear-cut example of a court legislating from the bench. No one asked them to address this. No one said, can we overrule Russell? And again, the facts of the case involved a new period of temporary total, not an ongoing period. Courts aren't supposed to address anything other than the factual issues before them. That's a doctrine that's called judicial restraint. That does come over from England. That is part of common law. That's been part of judicial tribunals going back to Greek and Roman times. But apparently that was not something that the Dillon court here with the Ohio Supreme Court was thinking about when they did this. So now what we have is we have the undermining of a very clear-cut portion of the law. So now what we have after this Dillon case is, whether it's an ongoing period of compensation or a new period of compensation, the hearing officers are terminating temporary total back to the date either of the report or of the exam. And again, which one is it supposed to be? We don't know. Dillon didn't give us any guidance, and the Industrial Commission hasn't told us. That can make a big difference. If you have, for example, a very complicated factual scenario for a doctor to look at where there's tons of medical records and they maybe have to look up medical literature, or, for example, the doctor examines somebody on January 1st, and then, anything can happen in someone's life. They get sick, their spouse gets sick. They don't get that report out, say, to the end of January. There's 30 days there. Which is the correct date? The date that the doctor examined or the date of the doctor's report? It can make a big difference. We don't know. Dillon didn't tell us. The Industrial Commission hasn't told us. So you have all these hearing officers who have no idea how they're supposed to apply Dillon, which puts them in a very, very difficult position. It's very, very hard for hearing officers to do this. What I personally have seen since the Dillon case is a little bit of chaos. Honestly, you have some hearing officers that say, I don't like Dillon. I think the case law that was decided before Russell, which was not overruled in Dillon, should still apply. And so I'm going to pay temporary total through the date of the hearing, consistent with the way it's always been done or done for a long time when you have an ongoing period of temporary total. And I've seen decisions that's what we argue for as injured workers representatives. And I've seen other examples. I've seen hearing officers saying, well, I don't like Dillon, but it's the law and I have to follow the law. That's what I'm supposed to do as a hearing officer. So I'm going to terminate temporary total, even though it was ongoing. I'm going to terminate it. And then I've seen some do it as of the date of the exam, and I've seen some do it as of the date of the report. So it's all over the map. It's very hard to predict. And when clients come to us and say, what's this all about? I got a notice of hearing and it says they want to terminate my compensation. What's going to happen? I have to tell that person, I don't know what's going to happen. We're going to go in front of a hearing officer, and depending on who it is and depending on what he or she kind of mood he or she is in and whether Venus is aligned with Mercury, we don't really know how this is going to turn out. And you could end up, even though they've been paying you on an ongoing basis for being off work, you're not doing anything wrong. Your doctor's submitting your Medco 14. You've submitted your C84. You're still off work due to the allowed conditions. Everything there is in place, but they can create an overpayment by choosing an earlier MMI date. And then you're going to have to pay that money back out of future awards. Now, you may think, okay, it's not that big of a deal. When they get their permanent partial award, they'll just have to pay back the overpayment. Well, to some people, that makes a huge bit of difference. And for injured workers, by and large, my clients are not wealthy people. My first responders do pretty well, but they're not CEOs. They're not people who own necessarily their own businesses or anything like that. So if you have someone who's living paycheck to paycheck, and they get an overpayment created by Dillon, and when they get their permanent partial award, 40% of that goes out the window. That you better believe that makes a big difference to people like that. And you also may think, well, how much does this really add up to? Well, I can tell you this. We just got the updated statistics from the BWC. Now, this does not mean that they've recouped all of this overpayment, but based on Dillon overpayments, since this decision was decided about 6 months ago, they have created about $2 million in overpayments that would never have existed before. Now, that's a lot of money. I don't care who you are. It's definitely a lot of money to injured workers and working people.
Over how many injured workers does that money spread?
They didn't give us those data. They just
Hmm.
told the total amount. But it differs for everybody because again, you can have much longer overpayments created. For example, if they go back to the date of exam as opposed to a report. So
Right.
it's very hard to predict.
Yeah,
But
depending
and
on
now
how
that doesn't
long it
mean
took to get a motion filed, to get a hearing set, how many times did it
exactly.
get continued? It can,
Yeah.
it
So
can be
all
quite a
the
long time.
it can absolutely be a long time. And Angela brings up a great point. We have a lot of things that are difficult on their own. The nature of our system is somewhat unpredictable. There's a lot of delays. There's a lot of things that we just can't control due to the administrative process. And now we have one more thing that we can't control, which is we can't tell our clients how long their money is going to go for. And if it's going to be terminated, when's that date of termination going to be? So um, there, there's talk about maybe doing some type of legislative fix. Again, the BWC doesn't like this. The Industrial Commission doesn't like it. The only people who potentially like it are the employers. But I've talked to some employers' counsel, and they don't necessarily like it because it creates an actuarial nightmare for them trying to recoup overpayments that they never had to worry about before.
Yeah.
Again, this is the danger of a court legislating from the bench. This is why we're all supposed to stay in our lane, right? When I talked about the VSSR cases and the Chevron doctrine, legislatures and administrative agencies aren't supposed to interpret laws. They're supposed to set forth the law. Okay, the courts interpret the law. In this case, you basically have the court creating the law. That's the legislature's job. That's not the court's job. And when you have one of the branches violate the separation of powers, you see what happens. Our system was designed a certain way. When James Madison sat down in his study and created essentially the frameworks of our constitutional system with the separation of powers, this is exactly the kind of stuff that he wanted to avoid because he saw examples of it in other countries, and things don't work when you have a court have too much power. Just similar things don't work when you have the legislature or a king or have too much power. The separation of powers is really completely genius, and it's something that we should be proud of as Americans because it's our own separate system that's worked better than pretty much anybody else's that's ever really been tried in history that we know about. So when someone messes with it, we should all be kind of, pissed off, quite frankly. Excuse my language, but you should be. You shouldn't read this Dillon case and think, you know what, that was correctly decided, because I can tell you it was not correctly decided. And it was decided by an allegedly conservative court. So when you say, oh, it's only liberal courts that legislate from the bench, well, here's an example of that not being the case. It doesn't matter who does it. Right is right, wrong is wrong. Stay in your lane is what the moral of the story is here. So it's going to be very interesting to see how this spins out. I know of one case that's pending right now in the 10th District Court of Appeals that's challenging this basically. And it's not just challenging the Dillon case. It's then because Dillon creates the overpayment. Then we have the separate issue of, okay, now that there's an overpayment that's been created under Dillon, how is that money recouped? If you read the materials there, you can see that there's a major problem with recouping it. Typically, the overpayment recoupment statute, which is RC 412311 11J, I think, what that says is you have certain ways that you can. I'm going to try to find this here in the materials. Sorry, I get going and then I lose my train of thought. Yeah, I'm sorry. It's 4123.511K. This is the statute that tells us how we're allowed to recoup overpayments. Overpayments can't just be recouped willy-nilly. The BWC doesn't get to just decide how that's done. There's statute and there's laws explicitly stating what type of overpayments can be collected, how they're supposed to be collected, and from what type of compensation they're supposed to be collected. For example, if someone is in a voc rehab program and they're getting living maintenance, did you know that you cannot recoup overpayment from living maintenance? Well, you say, why is that? Well, it's not listed in the statute here in terms of money types of compensation that you can recoup from. So the reason all this matters is what the statute says is you can recoup overpayments, but it has to be due to a reversal on appeal. In other words, I was previously granted a period of compensation, and then something happened where that decision was later reversed on appeal and it created an overpayment. All right. That's not what happened in Dillon. there was never a award of compensation that was reversed on an appeal. It was a brand new period of compensation that was awarded. So how are you going to recoup money legally from a Dillon overpayment when it was not an overpayment that was created due to a reversal on appeal? That's not me being liberal or being an injured workers representative. That's what the dang statute says. So you've now, the court has created this problem with Dillon for everybody, and now they've also saddled self-insured employers and the BWC with basically trying to recoup overpayments in a way that is not sanctioned by the law. So you see the cascading effects of a bad decision where a court legislates from the bench. It's very frustrating. So I'll get off my soapbox with that. I think we're at the 1 hour mark. Hope I haven't bored you to tears. If you want to read stuff, there's a lot more materials in the documents
Yes.
there that are provided, and I'm more than happy to. I did want to say one other thing, and I know this is going to be, I think, and I should have spent more time on this, but this is very important. I write a lot of mandamus briefs, so I'm very picky about citation, and I think probably as paralegals, you guys know a lot about citation and how you're supposed to cite statutes in court cases. There's been a major change in that. The Supreme Court of Ohio puts out something called the Manual of Citations, and they changed the way that you do citations. So I can send something to Angela, but you can look it up on the Supreme Court website. They have greatly simplified the way that you cite cases. For example, if you have a case it's called Smith, so you put the case number, right, and then you have what they call the Ohio site, 2024-Ohio- the numbers after that. Under the existing rule before they made the current changes, you had to put what county it came from, you had to put the case number of the appellate court, all these things, and you would end up having 2 lines of text in order to cite a single dang case. They have greatly simplified that now. All you need to do is have the case name and then the Ohio citation, so 2024-Ohio- whatever. If it's an Ohio Supreme Court case, that's all you need to do. You just have the case name and you just have the Ohio site with 2024-Ohio and then the numbers. If it's a Court of Appeals decision, all you have to do is have those 2 things, and then in parentheses behind the citation, you put which appellate court it came from. So for example, if it's a 10th district decision, State versus Smith, 2024-Ohio 1234, and in parentheses 10th district. That's it. No more appellate court cases, no more saying what county it came from. It's greatly simplified, and it'll, I think, make brief writing and hopefully, things that you guys do as paralegals much easier and simpler. And I can send something to you that summarizes.
Yeah, that'd be great. Thanks.
Yeah. So I appreciate everybody's time today, and thank you very much.
Okay. And John, we thank you, and we certainly appreciate your time and your expertise. It was a fascinating discussion. Before we do wrap up, though, I just want to give a couple of updates. Don't forget, and you will hear more about this in the coming weeks. We are having a fall happy hour. It will be held on Wednesday, October the 9th from 6 to 8 at Edison Brewing in Gahanna. And our sponsor for that event is going to be U.S. Legal Support. We have our next general membership meeting on October 15th. Private investigator Michael Kenny of Observe Investigations will join us. Mr. Kenny is the author of a book titled Think Like a Stalker and Stop Them, and he will share his insights from handling high-profile stalking cases. And finally, our next Workers' Comp Roundtable next month on Thursday, October 17th at noon, Attorney John Bauer will be discussing loss of use awards. And registration for all of those events are on the website. Please check it out and sign up, and we can't wait to see you again. Thank you, everyone, for your time and attention today. And again, Mr. Goodman, thank you for your time and expertise. We very much appreciate it.
Thanks, Angela. Appreciate it.
Have a great day, everyone.